My apologies once again, ma'am. That's Honorable Justice Binta Yako from the Federal High Court. Thank you, ma'am. A round of applause for her, please. Honorable Justice Jude Owebuzie from the FCT High Court too is here with us. Can you take your seat at the high table, sir? Honorable Justice Jude, a round of applause for him. Honorable Justice Aliyu Shafa, Judge of the High Court, FCT. A round of applause. He's also here with us. Honorable We also have in our midst this afternoon, Honorable Justice Abdurrahman Usman, Judge of the FCT High Court. Thank you for joining us, sir. A round of applause for him. We have Honorable Justice M.O. Anene from M.E. Anene from the FCT High Court. Also a round of applause for him. Please take your seats at the high table, sir.
Chairman ICPC.
Honorable Justice Binta Muhammad is also here with us. A round of applause for her. Can you join us at the high table, ma'am?
ICPC.
We have Honorable Justice G.N. Oji. C.N. Oji. Honorable Justice C.N. Oji. Please take your seat at the high table, ma'am. A round of applause for me. We also have in our midst this afternoon, Dr. Adamu Musa, SAN, is the Chairman, Independent Corrupt Practices and Other Related Offenses Commission, ICPC. You're most welcome, sir. A round of applause for him. And of course, our host for today's event, the Vice Chancellor, University of Abuja, Professor Hakeem Fawaimi. A round of applause for the Vice Chancellor. Thank you for joining us, sir. Honorable Justice Aliyu Shafa, Judge of the High Court, FCT, is here with us. We appreciate your presence. Thank you for joining us, my Lord. Justice Abdurrahman Usman, FCT, Federal High Court. Thank you, FCT High Court. Thank you for joining us at this event. A round of applause for him. We also have the Honorable Justice Abdullahi Adam Ali Lori, a Qadi of the Sharia Court of Appeal, FCT, here representing the Honorable Grand Qadi of the Sharia Court of Appeal, Abuja. Thank you for being here, sir, my Lord. Thank you. A round of applause for him. Please, would like the Qadi to join us at the high table. Please take your seats at the high table, my Lord. Learned Silks, distinguished members of the bench and bar, esteemed academics, honored guests, ladies and gentlemen, a very good afternoon to you and thank you all for being here. It's my great privilege and honor to welcome you to the 2026 Chief Judge, Annual Lecturer of the Nigerian Bar Association, Gwagwalada Branch. We'd like to recognize the presence of Professor Yemi Akinseye George, SAN, and Mr. Kehinde HC, SAN also. Thank you, sirs, for being here. We appreciate you. The ICPC chairman, please take your seat at the high table. Oh. Thank you. Please, can we have an extra seat for the high table? Thank you. Honorable Justice E.D. Honorable Justice E.D. Zubilin, representative of the President National Industrial Court, is here with us. Thank you, sir, for joining us. We appreciate your presence. A round of applause for him. Please, let's have some extra chairs at the high table. All right, once again, you're most welcome to the 2026 Chief Judge Annual Lecture of the Nigerian Bar Association, Gwagwalada Branch, that's the Eagle Branch. And today, of course, we gather here under a theme that speaks directly to the pulse of our nation's democracy: judicial independence under strain, reasserting the authority of the courts in Nigeria's constitutional democracy. For me, this is more than a topic, it's a call to conscience, a call to reflect on the pressures confronting our judiciary, and a call to collectively reaffirm the sanctity, the authority, and the independence of our courts. And at a time when the rule of law must stand firm against all odds, this forum offers us the opportunity to engage, interrogate, and chart a way forward. Once again, you're all welcome, and please, I invite you to be fully part of this important national conversation. For now, we take the national anthem. May we all rise for the national anthem. Thank you. The national prayer, please, the national prayer now. As we remain standing, let's take the national prayer. No, national. National prayer. We just take the second stanza of the national anthem for the national prayer. Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians all and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle, honored, and this we count as gain. So hand on to our children a banner without stain. O God of all creation, grant this our one request. Help us to build a nation where no man is oppressed, and so with peace and plenty, Nigeria may be blessed. Amen. The NBA prayer, please. Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavors so that we shall continue in all humility to glorify thy name and do that which is right and just for our profession, its members, our fellow men, and our country. Amen. We may be seated. At this juncture, I would like to recognize the mother of this branch, who equally is the chairman planning committee for this event. And I'm talking of no other than Professor Mrs. Josephine Agbonika, SAN. A round of applause for her, please. Thank you, ma'am, for being here. Thank you for all you do. We have the Dean, Faculty of Law, Professor C. Uwakwe Abugu. A round of applause for him, Professor Abugu. The Chief Magistrate, Idayat Akone, and Nectar, Director Magistracy, FCT. You're most welcome, madam. Thank you, my lord. Chief Magistrate Fola Shade Oyekon, Director Litigation, FCT. We appreciate your presence. A round of applause for her. Other magistrates here present, we appreciate your presence. Thank you. We move straight to the next item on the order of events. And that is welcome address by the Chairperson Planning Committee, Professor Josephine A. Agbonika, SAN. A round of applause for her as she steps forward.
Distinguished Chairman of this occasion, Honorable Justice Hussaini Baba Yusuf, Chief Judge of the High Court of the Federal Capital Territory, my lords, honorable judges, learned silks, and distinguished members of the bar, esteemed academics and political makers, invited guests, ladies and gentlemen, Please permit me to stand on the already established protocol. It is with profound honor and deep sense of responsibility that I welcome you all to the 2026 Chief Judge Annual Lecture of the Nigerian Bar Association, Gwagwalada Branch. This gathering is not merely ceremonial. It is, in essence, a convocation of critical minds and stakeholders within the justice sector. We meet at a time when the very foundation of our constitutional democracy demands rigorous interrogation, intellectual engagement, and principled defense. The theme before us, judicial independence under strain, reasserting the authority of the courts in Nigeria's constitutional democracy, is both timely and compelling. It reflects a growing concern within our legal system that the judiciary, which stands as the guardian of the rule of law, is increasingly subjected to pressures, whether institutional, political, or societal, that threaten its authority and efficacy. Judicial independence is not an abstract ideal. It is a constitutional imperative. Without it, the enforcement of rights become uncertain. The interpretation of laws become vulnerable, and the confidence of the citizenry in the administration of justice is inevitably eroded. In Nigeria's constitutional architecture, the courts are designed to serve as the final arbiters of disputes and the ultimate protectors of civil liberties. However, where judicial authority is undermined, whether through disregard for court orders, undue interference, or systemic inefficiencies, the consequences reverberate far beyond the courtroom. They strike at the heart of democratic governance itself. This lecture, therefore, is conceived as a platform for frank, scholarly, and solution-oriented discourse. We must collectively interrogate the nature and extent of these strains, and more importantly, articulate the pragmatic pathways for restoring the dignity, authority, and independence of our courts. It is our expectation that today's deliberation will not end as mere academic exercise, but will translate into actionable reform, strengthening international safeguards, reinforcing ethical standards, and fostering a culture of respect for judicial pronouncements. In conclusion, it is our fervent expectation that today's deliberation will go beyond theory and academic exercise to inspire actionable reforms, strengthen institutional safeguards, and reinforce ethical standards. On behalf of the Planning Committee, I express our deepest appreciation to our distinguished chairman, Honorable Justice Hussaini Baba Yusuf, and to all participants whose presence underscore the weight of these issues. I urge you to engage with openness and intellectual rigor as we strive to preserve the sanctity of the judiciary as the last hope of the common man. It is my honor and privilege to warmly welcome all to declare the lecture open. I must not fail my duty by not apologizing profusely for starting this occasion this late. I want to apologize for our laxity. Thank you very much, and God bless the Federal Republic of Nigeria. God bless you.
Please, can we give another round of applause for Professor Mrs. Josephine Agbonika for that very warm and inspiring welcome address. You're all welcome once again. Please, at this juncture, I would like to encourage us, every other speaker that will be coming here to make a speech, please, we have a host here who is hosting every one of us here, and we are using this facility, and that's talking about no other person than the Vice Chancellor of the University of Abuja, Professor Hakeem Fawemi. So please, even if you are standing on existing protocols, we'd like you to acknowledge his presence. Thank you for your understanding. I would like to recognize the presence of Mrs. Evu Igbinedion, Executive Secretary, Administration of Criminal Justice Monitoring Committee, ACJMC. A round of applause for her. The representative of the representative of the ICPC chairman should please take his. Okay, the ICPC chairman is here, so he's on the high table already. The representative of the president of the National Industrial Court would like to have you at the high table. Thank you, sir. Representative of the president of the National Industrial Court, please join us at the high table. Thank you very much. We're still going to take another welcome address at this point, and this time by the chairman, MBA Gwagwalada Clever and Onwo Esquire. A round of applause for the chairman, Eagle Branch, as he gives us his welcome address.
Thank you, the MC. My Lord, Honorable Justice Oseni Baba Yusuf, the Honorable Judge of the Federal Capital Territory, Your Lordship, may I seek your leave to stand on the established protocol. On the course of that, Your Lordship, may I also seek your permission to recognize the VC of the university who have just stepped out, our host, and respectively the Dean of the Faculty of Law. On behalf of the executive and the entire members of the Nigerian Bar Association, Gwagwalada Branch, Your Lordship will want to single-handedly and respectively apologize for starting on this program behind the shadow. It is my singular honor and privilege to warmly welcome you all to the Chief Judge, High Court of Federal Capital Territory Annual Lecture 2026. We are deeply honored by your presence and grateful that you have taken time out of your very demanding schedule to be part of this important intellectual engagement. This annual lecture represents one of the flagship programs of our branch, carefully designed to serve as a platform for thorough reflection, constructive and dignities, and meaningful engagement on issues centered to the administration of justice and substance of the constitutional democracy. The theme of this year lecture, Judicial Independency under the stream recessing and the authority of the court in Nigeria is a constitutional democracy. Speaking directly to the reality of our time, this is no doubt that the judiciary remains the last hope of the common man. However, the hope can only be sustained through the courts and independence. Their authorities are respected and their decision obtained without hesitation. This lecture is therefore concerned as an opportunity for us, members of the branch, the bar, and the academia, to critically examine the challenges confronting judicial independence and to collectively explore pathways for strengthening the integrity and authority of our courts. We are particularly delighted that this year's lecture features a distinguished lineup of eminent jurists, respected senior advocates of Nigeria, and renowned academics whose contributions will undoubtedly enrich the discourse and deepen our collective understanding of this issue at hand. A major highlight of today's event is the unveiling of the special edition of the MBA Gwagwalada Law Journal in honor of the Chief Judge of the High Court of FCT. This publication represents our modest contribution to the legal scholarship and a lasting tribute to the institutional leadership within the judiciary. Permit me, Your Lordship's presence at this junction to express our profound appreciation to our distinguished guests whose presence has made this event possible. We remain grateful for your commitment to the advancement of the legal profession and justice sector. As we proceed, I encourage all participants to engage actively, share insights freely, and contribute meaningfully to the discussion. It is our expectation that this lecture will not only provoke thoughts, but also inspire our actions and reform. Once again, Your Lordships, I humbly welcome you all to this sincere and certified CJ lecture. We are most grateful, sir. Thank you.
Let's appreciate the chairman of the Eagle branch once again. And of course, the hope of the common man can only be sustained in the courts. And this is only possible where the judiciary, enjoys independence, no interference with the judiciary. Thank you very much once again. At this point, I'd like to recognize the presence of Barrister Samaila Abdul, Executive Director, Administration, NSITF, and is here representing the Managing Director, NISTF, that's the Nigeria Social Insurance Trust Fund. We also have a round of applause for him, please. Thank you. We also have one of the discussants for today's event, and that's he's an activist. I've known him for a while, Mr. Frank Tietie. Thank you for joining us. A round of applause for Mr. Tietie. Okay, we move to the next item, and that will be we'd like the representative of the MDNSITF to join us at the high tables. Sir, please come up. A round of applause for him as he steps forward. Please, let's appreciate him one more time. Thank you for joining us. It's time to take a few goodwill messages. But please, I would like to encourage us to keep our goodwill messages very brief and straight to the point. We have just a minute each. everybody that will be calling out here to come and give a goodwill message, please be mindful, be conscious of time. You have just 60 seconds to give your goodwill message. And the first person on the list here, DJ, please, could you raise the volume of the music for now? Mr. DJ, please keep it low. Thank you. The first person to give us his goodwill message on this occasion is the Chairman ICPC. A round of applause for the Chairman ICPC as he steps forward.
Thank you, MC. My Lord, the Chief Judge of the Federal High Court of Federal Capital Territory, Abuja, and my Lord, on the high table, all protocols duly observed. Although I am not aware that I'm going to give a goodwill message, but notwithstanding, I want to commend the MBA Gwagwalada branch for organizing this important engagement. And we at ICPC, we always like this kind of intellectual discussion because there is need for close collaboration between the Nigerian Bar Association, the judiciary, and the academics, so that we will look at the topical issues that is facing our profession, so that those who are well known in the area can sit down, look at the issues, discuss, and propose solution. And we in ICPC, we have been participating in this kind of engagement. And also, we are trying to see how we can bring up law students into the anti-corruption fight in this country. And currently, the ICPC, the Nigerian Law School, and Nigerian Law Teachers Association, we are going to have a robust discussion on how we are going to push for teaching of anti-corruption in the universities, most especially those at the final year level and Nigerian Law School, because we have discovered that we need to catch them young, so that those who are going to join us in this profession need to understand the challenges that our profession is facing in terms of corruption and also issues around accountability and transparency. And for this topic, which is going to be discussed, it is timely and important. And one issue which I want to just make a few remarks, which Professor Agboni can talk about, is the issue of pressure which the judiciary is having, most especially in the society. In my view, we in the legal profession, we are the enablers of this pressure, because some of us are going into the media giving some contradictory interpretation of laws and also even case law that are live before court of law. And sometimes we are confusing members of the public. That is why sometimes the members of the public are now engaging in discussion on issues of law that they do not know. So I want to appeal to those of us in the legal profession to exercise caution and restraint in trying to push narratives which we want to push our case or narrative of others, so that at least we will protect those on the bench, because those at the bar, we are their mouthpiece. My lawyers cannot go on TV or on any media to start to discuss issues around law. So I wish to congratulate the MBA Gwagwalada branch, the Faculty of Law of University of Abuja, and also my Lord, the Chief Judge of FCT, for supporting this. Thank you so much.
Thank you, sir, for that promise of a huge support. Thank you. Of course, taking our judiciary to where it should be is actually a collective responsibility. All hands must be on deck. Everyone has a role to play. Before I call the next person to give us a goodwill message, I'd like to recognize the presence of Mr. T.J. Aonodo, SAN, is here representing Chief Dr. Monday Ubani, SAN. Thank you for joining us, sir. I would like to invite the representative of the MD NSITF to come give his goodwill message. A round of applause for him as he comes forward.
The Chief Judge of the Federal Capital Territory High Court, please permit me to stand on the well-established existing protocols. On behalf of the Managing Director of the Nigerian Social Insurance Trust Fund, I bring this goodwill message as follows. I bring you a warm greeting from the Managing Director, Chief Executive of the Nigerian Social Insurance Trust Fund, who has asked me to convey his goodwill and deep appreciation for this kind invitation, while also apologizing for his inability to be physically present due to pressing official engagement. Let me bring my commending the Nigerian Bar Association Gwagwalada branch for establishing this important intellectual tradition. The Chief Judge annual lecture continues to stand as a vital platform for reflecting dialogue and tough leadership on issues central to administration of justice in Nigeria. The theme of this year's lecture, Judicial Independence Under Strain, Reasserting the Authority of the Courts in Nigeria, Constitutional Democracy, is both timely and profound. Judicial independence remains the cornerstone of any credible democratic system, where the judiciary is strong, impartial, and protected. The rule of law thrives, and where the rule of law thrives, institutions, public and private alike, are strengthened. Citizens are protected, and national development is sustained. At the Nigerian Social Insurance Trust Fund, NSITF, we recognize that the effectiveness of social protection system is closely tied to the strength of legal and judicial framework. The enforcement of rights, the protection of workers, and the resolution of disputes all depend on the judiciary that is not only independent, but also respected and empowered. This is why conversations such as these are not merely academic, they are fundamental to nation building. As stakeholders in governance, law and public service, we all share a collective responsibility to uphold sanctity of our institutions. The judiciary must continue to serve as a beacon of fairness, accountability, and justice, especially in times of strength. Let me also commend the leadership of the bench and the bar for their continued commitment to strengthening the justice sector and for creating platforms that encourage meaningful engagement across the sectors. It is our hope that the deliberations from this lecture will generate practical insights and actionable recommendations that will further reinforce the independence and authority of our courts. On behalf of the Managing Director and the Chief Executive of Nigerian Social Insurance Trust Fund, I congratulate the organizers of this laudable initiative and wish all participants a productive and peaceful session. Thank you and God bless.
Thank you, sir, once again for that goodwill message. The next person to give us a goodwill message is the representative of the Grand Qadi of the Sharia Court of Appeal, FCT, and that's Honorable Justice Adam Alailori. A round of applause for him. Okay, we'll come back to take more goodwill messages as the program moves on. For now, we take the keynote speech by the President, Court of Appeal, Honorable Justice M.B. Dongba Mensam, CFR, here represented by we'll actually invite the representative of the Honorable, the President of the Court of Appeal. That's Honorable Justice M.A. Danjuma. He's the Presiding Justice, Court of Appeal, Abuja Division. A round of applause for him.
My Lord, the Chairman, of this forum, His Lordship, the Chief Judge of the Federal Capital Territory, my classmate, but my elder brother, distinguished dignitaries on the high table, jurists, learned gentlemen, ladies, and invited guests. I am Mohammed Ambiu Sidanjuma. I am the presiding justice of the Court of Appeal, Abuja Division. I got on board on transfer just 1st of April, but I had been the presiding justice for the past 6 years in some other divisions, the last being in Kano. I represent the Honorable President of the Court of Appeal, His Lordship, Honorable Justice Monica Dongba Mason, CFR, JP Daga, had sent a message to me while she was and still remains out of the country for engaging national assignment, asking me to represent her in this forum. And I had actually started scribbling my thoughts on the topic when I received the invitation as sent to me. But after a while, few hours thereafter, I contacted our Director of Legal Services, Barrister Samira, to get over to the President to see the possibility of having her scripted keynote address so that I could get straight to the point, because I had read exactly the great expectations from the Honorable President, His Lordship, Monica Dongbe Mercy. And it came very timely this morning. Therefore, I would keep mine, which I had prepared, but if you are willing to read, I would leave a copy for you. But I would, in obeisance to the rule of law, orderliness, and respect for the system, read exactly the keynote address as prepared by His Lordship, the Honorable President of the Court of Appeal. And I go straight to it. I crave your indulgence to stand on the well-established protocol, having recognized the chairman of the forum, His Lordship, the Honorable Chief Judge of the Federal Capital Territory, earlier. It gives me great pleasure, and indeed, I am full of gratitude to Almighty God, and with a deep sense of privilege, I address this distinguished gathering at the Chief Judge of the Federal Capital Territory annual lecture series holding in Abuja. I warmly commend the organizers, that is the Nigerian Bar Association, Gwagwalada branch, for sustaining this all-important platform for reflection on issues central to the administration of justice in Nigeria. Judicial independence is the bedrock of Nigeria's constitutional democracy. Our gathering here today is not merely an opportunity for engagement only. It is indeed an invitation for reflection and introspection, which are the essential tools by which institutions are measured, by which institutions leverage their growth, renew themselves, and retain their relevance to the people they serve, the judiciary being one of such institutions. The theme of the conference, Judicial Independence, under strain, reasserting the authority of the courts in Nigeria's constitutional democracy, is both timely and necessary. It calls attention to the growing reality that the independence of the judiciary, though constitutionally guaranteed, is increasingly subjected to strain. Constitutional and theoretical foundation for the independence of the judiciary. The Constitution of the Federal Republic of Nigeria, as amended, lays down a clear and comprehensive framework for judicial independence. Under Section 6 of the Constitution, judicial powers of the Federation are vested solely in the courts of law established by the Constitution or by any act of the National Assembly or by any statute of the state, as the case may be. Section 36 of Section 1 of the Constitution of the Federal Republic of Nigeria, 1999, reinforces these by guaranteeing every citizen of Nigeria fair hearing before an independent and impartial tribunal. To protect that independence in practice, Sections 81 subsection 3 and 121 subsection 3 secure the financial autonomy of the judiciary, while Section 292 guarantees the security of tenure for judicial officers. At the institutional level, the National Judicial Council, NJC, established under Section 153, has the central role of overseeing appointments, discipline, and the broader administration of justice. And to ensure compliance, Section 287 of the same Constitution makes the decisions of courts of law binding on all persons and authorities. The constitutional provisions are indeed not just legal technicalities. They reflect the enduring constitutional principles long articulated by Montesquieu on the separations of power and by A.V. Dicey on the rule of law. Both of these writers remind us of the simple truth that liberty and accountability in any society ultimately ultimately rest on an independent judiciary. Our courts have not left these principles of independence as mere words on paper. They have practicalized it daily in the performance of their duties to the nation. Time and again, the courts have breathed life into them. In the landmark case of the governor of Lagos State, Anojuku, citation provided for you, the Supreme Court affirmed that all authorities are subject to the rule of law. The courts have been fair in defending the institution that guides judicial independence. In Alelu Habib and the Attorney General of the Federation, citations provided, the courts reinforced the central role of the National Judicial Council as a shield for the judiciary for the common good of protecting human rights and liberty to ensure that the rule of law triumphs at all times. Our electoral jurisprudence tells the same story of a stabilizing judiciary. In Amechi and INEC citations provided, the Supreme Court of Nigeria stepped in to uphold the rule of law at moments of great political tension, reminding the nation that democracy survives when the courts stand firm. Notwithstanding these constitutional safeguards and judicial pronouncements, we must be candid to ourselves, and that is that the judiciary does not operate in a vacuum. It functions within a complex environment in the tripod of the separation of powers and the interrelationship between the various arms of government, the executive, the legislature, and indeed the judiciary, making that entity that constitutes the government for the common good of society. In this wise, therefore, institutional constraints, financial pressures, environmental hiccups, and the weight of societal expectations are bound to weigh and impinge on the judiciary as it does also on the other arms of the government. We are not an exception. These pressures or strains you may call affecting judicial independence are not abstract. They wear specific faces in our daily experiences in the performance of our functions and duties. Some of them may be listed as follows. I will simply give a resume without wasting your time. The uneven implementation of financial autonomy provisions, though the Constitution guarantees it, the judiciary in practice still struggles to access what is already its constitutional due as provided. Secondly, the intense pressure that comes with politically sensitive adjudication is well known to all of us. This is most pronounced in electoral disputes, where every judgment is scrutinized through the lens of sometimes partisan interests. The weight of public scrutiny, too, often descends into public misinterpretation and misinformation. Complex court decisions are recast sometimes in false headlines and hashtags, and the court's fidelity to law is mistaken sometimes for allegiance and oftentimes to taking sides. Indeed, the most corrosive to the rule of law is the willful non-compliance to court orders, with binding decisions disregarded by those duty-bound to obey them. It is not merely a judgment that is undetermined, it is the authority of the law itself that is being disrespected. This is a strain on the judiciary, and it corrodes and affects its stand for the service of motherland. Public confidence and judicial integrity. The judiciary occupies a unique place in our national life. It is both an arbiter of disputes and moral compass of society. In the dual role, therefore, public confidence becomes the true currency of judicial authority. This confidence is not necessarily inherited. It is earned daily through integrity of the individual judex and the collective entity, the judiciary itself. Consistency and steadfast fidelity to the law. For no system of justice can rise above the character of those who operate it. This is well known as stated by John Rouse. This is why adherence to the Code of Conduct for Judicial Officers and many multifaceted statutory regulations, such as the National Policy on the Judiciary, the Uniform Standards for the Assessment and Adjudication in Criminal Matters, indeed, the compliance and the safe standards for members of staff of the judiciary are out there, multiple and clear enough for judges, members of the third arm of government, knowing its pivotal role in the stability, the progress, the peace, the unity, and the advancement of the rule of law. Carefully and meticulously follow all these blueprints. Indeed, even without these statutory provisions, the judex in Nigeria is not unmindful of the constitutional provision, Section 6 of Section 6A thereof, that vests the judicial powers of the state on the judiciary. And this, the courts will continue to do. Okay, sorry. This, the courts will continue to do. We are so conscious of this responsibility. We are conscious of this burden. And we do know that nations across the divides get into ruins. They're destroyed where the rule of law is not respected, where the rule of law is not followed. And therefore, this great task is well known to us. It is a burden It is a duty, it is an obligation which we owe unto God and to fatherland. So we are not unmindful of this fact. Steadfastly we hold on to it, and those that understand the workings really appreciate. It is only when we're derailed by so-called man-made strengths that impressions are given as if the judiciary does not know why it is there. The judiciary does not need to reassert itself. It knows its duties, it adheres to it, and it must not usurp constitutional powers, contrary to the separation of powers doctrine, because all are geared towards a balance, a check and balance system, a system where we must collectively operate and work together for the common good. No usurpation and no abdication of duties or responsibility. That is what the judiciary in Nigeria stands for. Before I conclude, I should say that this is why adherence to the Code of Conduct for Judicial Officers remains non-negotiable. In moments of pressure for judicial officers, controversy, the judicial officer must have only two guides, and that is the law and his conscience shaped by the rule of law. This takes me to the role of the bar. Since I had stated that judiciary is not a law, it works in a society in communality with the other tiers of government, also with the other institutions of the state. The bar is an integral part, a partner in the observance and protection and the propagation of the rule of law for the safety of society. Therefore, the Nigerian Bar Association in the forum must emphasize that the relationship between the bar and the bench is the foundation of justice, where it is appropriately harmonized, articulated, and not operating riotously as if they are antagonists. They are not. They are partners in progress for the common good of society. Work harmoniously to sustain the administration of justice. This harmony imposes a duty on the bar, and its members, therefore, must, one, exercise disciplined advocacy, choosing arguments over abuse and substance over spectacle. And this takes me to a situation where you find in the Nigerian system a situation where parallel adjudication go on, sometimes by litigants or by uninformed. The Nigerian Bar Association owes a duty to educate the public and the uninformed that the rule of law will be in jeopardy where the judiciary cannot be trusted in the performances of its duty, where the judiciary is influenced by side commentaries as we see daily in newspapers, in the print, and social media, then it is an invitation to anarchy. Lawyers must refrain from filing frivolous or meritorious matters that only congest the courts and delay justice and frustrate the expeditious hearing of genuine claims. Present cases, lawyers must present cases with clarity and honesty of purpose, for the court can only decide on facts placed before the court in accordance to law and the application of the appropriate laws. And that is why in the courts you will always hear such expressions as the lawyer is a minister in the temple of justice and owes his primary duty to justice, to society, to the courts, because all are subject to the law. The law is not for the high or for any utopian common man. It is for all. The rich is deserving of justice. The government is deserving of justice. The governed is deserving of justice. And all of us, including the Judas itself, is deserving of justice. And that is why we must be knowledgeable. We must be disciplined. We must be honest and candid to ensure that the rule of law prevails. Where that is done, I think the practice of law in advocacy and adjudication should not be drawing the hula baloo that we see daily in this country. I dare say. I dare say. It is because some of us prefer grandstanding, serving the personal interest, political interest, social interest, economic interest, ego standing, ego flaring, and that is why we have all this. You will hear, sadly, in some of our courts, I am going to test this decision upstairs, as if the courts are a place for testing. The courts are not there as laboratories. The laboratories are there for scientific inventions and discoveries that will better the lives of Nigerians, and not to test for the so-called purpose thereof. Although I must admit that we realize that so many council, so many people, we always end up telling you, we understand, but we had to try. But how far shall we go in delaying proceedings, in sacrificing national resources, sacrificing useful time, impairing the fate of people by leaving the prisons the prisons congested, cases wallowing, small claims abandoned, merely because we want to articulate and test cases for the purpose of ego and grandstanding. I think enough should be enough if we must be honest to ourselves and to God, because it's a trust beholden upon us by God Almighty, which we must not fail. The proliferation of frivolous appeals, avoidable applications, places unnecessary burden on the judicial system, undermines the essence of justice. We must remember that we are not mere mouthpieces for our clients. We are ministers, there to guide and not to mislead. And that is why in this study of law, which is important for this audience, a university and an academic audience, there is this prayer said by one C.L. Samuel. He said, Lord God, give me that knowledge that I may attain that skill and competence and capacity, that I may direct nobly, justly, the innocent, the ignorant, so that at the end of the day, the glory shall be yours for the advancement of humanity. And that is why we should teach these younger ones in the universities and those uninformed outside there, because it's a special trust bestowed upon all of us as lawyers. We must not fail. The courts will, where necessary, continue to take appropriate measures, including the award of cost, and these the statutes provide, and these the inherent jurisdictions of the courts provide, to punish, indeed, in cost, such frivolous applications, such frivolous actions instituted without cost, without the intent of furthering the cause of justice, which can easily be discerned by the judges, carefully trained and meticulously watching and applying the law in all honesty. Are we coming to an end by stating that notwithstanding these challenges highlighted supra in summary form only, these challenges, the judiciary, in spite of these challenges, the judiciary has demonstrated resilience. The Honorable the Chief Justice of Nigeria, His Lordship Kekereke Okun, CJN, has set a clear tune and direction for the reform of the Nigerian judiciary. His Lordship has anchored on discipline, capacity, and innovation. The courts, therefore, are advancing speedily, meticulously, and guidedly within the rule of law with this agenda through strengthened disciplinary mechanisms, ongoing judicial education, and and the gradual integration of technology, including virtual proceedings, electronic case management, to improve efficiency, transparency, and access to justice. At the same time, the wider adoption of the Alternative Dispute Resolution Mechanism, ADR, reflects an evolving understanding that justice delivery extends beyond adjudication alone. Judicial independence exists not for the benefit of judges alone, but for the protection of society. It ensures that rights are safeguarded, that disputes are resolved in accordance to law, and that governance remains subject to constitutional limits. In conclusion, therefore, the issue before us is really not whether the judiciary is in strain. That is really not the pivotal issue. The real question is whether we are prepared collectively in our duty to society as the bench, the bar, and society alike to respond with discipline, integrity, and commitment required of each and every one of us as individuals or corporate entities for the preservation, the protection, and the advancement of the rule of law. That is the crucial point. That is the critical question. That is what we should be pursuing, rather than the ephemeral, surface-scratching criticisms that abounds the land. In closing, let us therefore reaffirm our commitment to the Constitution, the ground norm of governance, the ground norm upon which the rule of law rests, and to ensure that there is an enduring court system that is respected, that is ordered, that is highly proficient, educated, that is not swayed by unnecessary masquerading of antics in the name of being called strengths. And that is why I must state that the question of the judiciary reasserting its independence, to me, is inappropriate. Reasserting its independence is inappropriate. Rather, the judiciary will continue to assert, continue to advance what is its constitutional role and what it is already doing, but largely misunderstood by some. Let us therefore remind ourselves that judges are not mere referees of the law. We are not just mere referees of the law. We are custodians of justice. And that is why it is said that you are custodians to ensure that where even the statutes do not provide, you shall, by the powers conferred upon you, recognized by the Constitution that says, notwithstanding anything contained herein in this Constitution, the inherent powers and authorities of the courts of law is protected and respected and must be exercised. Therefore, the powers of the judex is not necessarily as found in statutes. Primarily, conscience, integrity, and knowing that it is the society that matters. Once that is the compass, we are ready to go. And this is important, particularly now that we are deep in the process of our next political dispensation. Cases are piled up, cases are coming, and we shall only be tested by the knowledge of the law, our integrity, and our full realization of our role. The judex must not coward. It must not be intimidated. It will not abdicate. It will not dance to any maneuvering for the purpose of being seen as being independent. It will simply do its work because we are all collectively accountable unto God. For this, we must preserve the trust We must preserve the very foundation of democracy, and I thank you most profusely for giving me this opportunity and privilege. Thank you.
Let's keep it going. I think His Lordship deserves a standing ovation for that insightful and thought-provoking presentation. Thank you. Thank you, thank you, thank you. Everyone deserves justice. Justices are custodians of justice, and justice must always be seen to be done. Get your questions ready and your contributions. We'll be doing all of that during the panel discussion. At this juncture, I would like to recognize a few more dignitaries here. We have Honorable Justice A.O. Otaluka, Judge FCT Abuja. Thank you for joining us, my lord. A round of applause for her. We also have Honorable Justice J.A. Aina, Judge FCT Abuja. My lord, you're welcome. Thank you for joining us. We move on to the next item on the order of events, and that's the panel discussion. And of course, the chairman and moderator of this session is Dr. Monday Onyekachi-Ubani, SAN, here represented by Barrister Aonodo. Aonodo, SAN also, is going to be moderating the panel discussion. But before then, I would like to invite to the podium Barrister Emmanuel Ogujide to give us a brief history of this event, how this event, the Chief Judge Annual Lecture, began, a few things we need to know about this event. So, Barrister Emmanuel Ogujide, please come forward and do that for us. Thank you. I would like to invite to the high table Okay, I'd like to invite to the high table Mr. A.T. Kennedy, SAN, and Professor Akishe George, SAN. Please, sirs, I'd like to have you at the high table. Thank you. Is Barrister Emmanuel Ogujide here for the... Okay, you're here. A brief history of this event.
I think on behalf of the chairman and for how well we have gone, can we give ourselves a round of applause one more time? Please, let it be better than that. It's a great day. Thank you. My lords, for the sake of time, distinguished guests, worship, my colleagues, I have the singular honor and pleasure to present to us a brief history about the Chief Judge Annual Lecture. I think we should celebrate MBA Gogara. I think this is the only brand that sees a program like this in FCT. You see, when you don't know the history about something, people say, this is inevitable. The Chief Judge, High Court of the FCT, Annual Lecture is a flagship intellectual initiative of the MBA Gogara branch. A program conceived to promote sustained engagement on critical issues affecting the administration of justice in Nigeria. The lecture that we're having today, I think the fourth or fifth of its kind, was first introduced in the year 2016 during the administration of Asiwaju A.A. Mohammed, the then chairman of the branch. Please, for his pioneering role, for his leadership, can you help me celebrate Asiwaju A.A. Mohammed? He's in the hall, my lord. He's there. In fact, I name him Asiwaju and is judicially noticed. a humble man, handsome man. He set the trend for us. We thought it was a joke. And he said, we need to keep learning and contributing to law. Sir, we will continue to celebrate you, sir. I know you don't like what I'm doing, but we need to. Thank you so much for that pioneering role, that initiative, that spirit of excellence. At that time, my Lord, a father to the branch, Honorable Justice Ishak, Usman Bello was the chief judge of the FCT. He graciously approved it in kind, in support, in presence. I remember I was in that planning committee and it was at Custom College. We gathered the creme de la creme of the judicial profession in Nigeria. And I know my Lord, the President, CJ, the chairman of today, was part of that program with his full support. A man of honor, another man of excellence, somebody that grew us, the man we call chairman of chairmen. Late I.G. Aruna chaired that organizing committee. May soul continue to rest in peace. This inaugural edition laid a strong foundation for what has since evolved into a respected platform for legal discourse within the FCT, in fact, the entire world. Building on this initiative, the branch sustained the momentum in the year 2017 under the leadership of Honorable D.A. Suleiman, the man we call the garrison commander. And as with the previous year, Honorable Ishaq Bello remained the chief judge of the FCT, while Asiwaju A. Mohammed served as the chairman of the second edition. This continuity of leadership and vision during this period further strengthened the national relevance of the lecture. Following a period of inactivity for about 4 or 5 years, and with the blessing of my Lord, our Baba, Baba is not just in his name, Baba in his what he does. We enjoy the revival. He prayed, blessed. I remember when we met him, my Lord, I will be there, we will do it. And you see, it is not about creating something, it's about sustaining it. And sustenance is not as important as if something is dead and is revived. And my Lord, the chairman today, helped us to revive this edition, while I humbly serve as chairman in 2024. In that edition, you can see we celebrate him. A. Mohammed still chair that edition. We couldn't do it without him. And it was excellent in this same hall. It was glorious. And all of you here gathered and celebrated with us. By this time, the chairman of today, my Lord, the Honorable Chief Judge of the FCT High Court, Honorable Justice Hussein Baba Yusuf, was the Chief Judge of the FCT High Court. This 2026 edition represents a consolidation of all past efforts, reflecting the branch's renewed commitment to institutionalizing the lecture as an enduring platform for high-level intellectual engagement within the justice sector. What are the objectives I will just run through? This lecture is to provide a platform for robust and informed discourse. We have had it today. We clap for the lecturers so far on contemporary legal and constitutional issues. Number 2, to promote and safeguard the principles of judicial independence and the rule of law. Number 3, to strengthen the institutional relationship between the bench, the bar, and the academia. Number 3, to contribute to policy development and reform within the justice sector. And also, to encourage legal scholarship and intellectual contributions to the development of jurisprudence in Nigeria. Why this lecture matters? What we do today is important because therein lies its role as a convergence point for critical stakeholders in the justice sector. In an era marked by evolving legal challenges and increasing public scrutiny of our judicial institutions, the need for thoughtful dialogue and collective reflection has become more pressing than ever. As I close, let me share a testimony. The last one we did as I went out, 3 students accosted me at the outside there, and they were thanking me. I said, for what? One said, we have never seen this kind of people. And the eyes show more than what they are saying. And the second one said, my life is touched. I won't remain the same again. Chairman, sir, you are talking about getting them from the grassroots. So don't just think we are just doing a program. If you want to clap, clap. We are doing something like when you are establishing the lighthouses, when you are re-establishing the beacons of hope and justice. The lecture provides a structured platform for interrogating emerging challenges facing the judiciary, affirming the central role of the court in constitutional democracy, bridging the gap between theory and practice through engagement between practitioners and academics, promoting public confidence in justice system beyond the immediate impact, the lecture contributes to the development of a body of knowledge and institutional memory, particularly through the publication of scholarly works, such as the MBA Kokada Law Journal. I think we are still one of the few branches that in 12 years we have published about 5 journals. My Lord Chairman, last edition we launched 2 editions here. And I think today we have another edition. I'm aware this administration already has published 2. And that's because we have the support of the university. Thank you, Dean. We thank the university and all what you are doing for us. My lords, your worship, distinguished learned 6, my amiable colleagues, my fellow student, I'm still a student. Over the years, this Chief Judge Annual Lecture has evolved from a pioneering initiative into a significant intellectual tradition within the Nigerian Bar Association, Gwagwalada branch. It continues to serve as a platform for shaping discourse, influencing policy, and strengthening the administration of justice in Nigeria. Let me leave you with this quote by a woman I love so much, Maya Angelou, a great woman, American poet. He said, people will forget whatever you do to them. People will forget whatever you say to them. But he said something, people will never forget how you make them feel. Our distinguished guests, distinguished participants, MBA Gwagwalada will never forget how you make us feel. In the past, today, and tomorrow. Thank you so much. Thank you, my Lord.
Another round of applause for Barrister Emmanuel Ogunjide for that brief history of today's event. That's the Chief Judge Annual Lecture. We move to one of the big reasons why we are here today, and that's talking about the panel discussion. And as I announced earlier, the moderator of the session is Dr. Monday Onyekachi Ubani, SAN, here represented by Mr. Aoduni, SAN also, is the chairman of the panel discussion and also the moderator. And of course, the panelists, I'll start from Her Lordship, Honorable Justice Binta Inyako. She's one of the panelists. Please, Ma, would like to take this. A round of applause for Her Lordship, please. We also have as panelists Professor Yemi Akinseye George, SAN. Professor Akinseye George, a round of applause for him. He's one of our panelists. And last but not the least is Mr. Frank Tietie. Mr. Frank Tietie, you're a panelist. Please take your seats on any of the white chairs. And the moderator, I'm sure, is out here already. Mr. Aoduni, representing Dr. Monday Onyekachi Ubani, SAN. You are the moderator of the session. Okay, he's here. A round of applause for him. Please get your questions and contributions ready. We'll take a few questions at the end of the session. Thank you, and please enjoy and learn.
Thank you very much. Before we go into this session, may I humbly read out what the chairman, Mr. Monday Ubani, Senior of Nigeria, did prepare and sent forth to me. I want to say, distinguished chairman of this occasion, Honorable Justice Hussein Baba Yusuf, Chief Judge of the High Court of the Federal Capital Territory, our very own. I want to use this opportunity to stand on the existing protocol. I'm going to read very quickly. It is both a privilege and a solemn responsibility to moderate this important conversation on the theme, judicial independence under strain. We are asserting the authority of the Nigerian courts under constitutional democracy. Few topics are more central to this life of a democratic society than the health of judiciary. In every constitutional order, the judiciary is the institution entrusted with the sacred duty of interpreting the law, protecting rights, resolving disputes, and ensuring that power is exercised according to the legal limits. It is the impartial arbiter between citizens and the state. Judicial independence is not a luxury. It is the lifeblood of the rule of law. Where the courts are respected, citizens find hope in lawful remedies. Where the courts are weakened, Society drifts towards arbitrariness, impunity, and distrust. In Nigeria today, the judiciary occupies a unique and elevated constitutional position by virtue of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Judicial powers are vested in the courts. Those powers are not for the decoration. They are substantive, enforceable, and foundational to the rule of law. The courts should not be appendages of government. They are a co-equal arm of the states, charged with checking excesses, preserving constitutional balance. Yet the reality before us shows otherwise. In recent years, concerns have grown regarding pressure on judicial independence. This pressure emerges in different forms: executive disregard of court order, delayed enforcement of judgment, financial dependence of judiciary, allegation of corruption, political charge, litigation, attacks on the reputation of judges, forum shopping, undue public commentary on pending cases, and growing frustration by citizens over delay in justice delivery. This development raises urgent question: can courts remain authoritative when their decisions are ignored? Can judges be truly independent where institutional autonomy is uncertain? Can public confidence survive where justice is delayed or where perception of partiality grows? Can constitutional democracy strive in the final arbiter of disputes? Is itself on the strain? The answer to these questions matters deeply. Judicial independence is not a privilege created for judges. It is a safeguard created for the people. It ensures that a citizen can challenge the government and still obtain a fair hearing. It guarantees that minorities are protected from the tyranny of majorities. It assures investors that contracts will be enforced. It provides political contestants with lawful avenues of redress. It offers society an alternative to self-help and disorder. When we speak of judicial independence, we must appreciate that it is at least three dimensions: institutional independence, decisional independence, public confidence, morality. Access to justice is not about law. The most critical component is about the human being that administers justice, dispense justice, oversee justice to the system. The burden now on we legal practitioners, private legal practitioners, is that there's a lot of mistrust in the judiciary, and all eyes is in the MBA, on the MBA. We members of the bar have a trust issue when it comes to morality, and it is time and conscience. A moral revolution must be brokered now. A moral revolution must be taken up now. We must look ourselves critically and tell ourselves the truth to reduce the perception and reduce corruption in our society. I must use this opportunity to charge every member of the bar, those of us seated here. Ethically, it depends on us how we decide to drive the system. The perception of how we look at the bench, how we look at the judiciary, our conduct, our candor, how we behave, the manner at which we take ourselves, we should give trust to the judiciary. And I've always said, in several fora, I've said it oftentimes, the judiciary is the only mechanism that have a system that purges itself, not the legislature or the executive. We have a mechanism through the NJC that checkmates every one of us. The Judex, it checkmates them. And to we members of the bar, we must support the system. Outright criticism, open criticism, saying all manner of things without looking in depth to how decisions are being given in court will not help us ethically. And I want to beg every one of you, as we go into this discussion, there are critical questions that will be posed. As I step down, I'll pose this question, I'll ask this question one and after the other. And all questions to be asked from the audience, and our discussion, I believe, at the end of the day, will have a very fruitful and peaceful discussion. God bless you all. Sorry, I had to summarize it because it's so lengthy and time is fast spent. Thank you so much. My lord,
My Lord, the Honorable, the Chief Judge of the Federal Capital Territory, the Vice Chancellor, University of Abuja, all other protocols observed. You know, in the judiciary, we are not used to protocol. You just come into court, you read your judgment, and you go. It doesn't matter who, even if it's the president of Nigeria, you don't introduce them, you don't recognize them in your judgment. Now, this, what I have said, is a foundation to independence of the judiciary and the separation of powers, which goes to the topic of today, the challenge of the judiciary. Don't let me misread it, let me quote it as it is. Judicial independence, under strain, reasserting the authority of the courts in Nigerian constitutional democracy. Now, like I have said in my introduction, when the court comes in to deliver judgment against the president or in favor of the president, it does not recognize that there is a person called the president in front of the court. It only recognizes that there is a litigant. Now, once a court decides that you understand that there is a division of powers between the three arms of government, then you will now know your worth. When you know your worth, you will now know that you are independent of the others. Now, this independence is not airtight independence. Independence is independence of the court administering justice according to the law, according to the rule of law. When you say independence of the judiciary, you do not mean that the judiciary is going to go out and start generating revenue to run the courts. That is the responsibility of the executive. So there is some areas of interdependence. Now, when it comes to talking about independence of the judiciary, first of all, you look at the Constitution. The Constitution creates three arms of government and makes them independent, and the judiciary is independent. The foundation, of course, is in the separation of powers, in the security of tenure of judges. You see, a judge that is afraid that I'll be sacked tomorrow may not be independent. He may be dancing to the tune of a master. But if you know that your tenure is secure, then you are more free to dispense justice according to the rule of law, which is the basis of the rule of law, which is also the basis of the foundation of the independence of the judiciary. For a judge sitting as a judge to determine a dispute between parties, to do so independent of any external influence but the facts before the judge and the law governing the subject matter. So this is very important. Now, why is the judiciary under strain? One of the reasons, very glaring, is interference. Interference from the executive, particularly. It could also be from the legislature. But when you talk of interference, are you saying that the executive is coming to come and write your judgments for you? No, the executive is influencing you into which direction they want the judgment to go. Now, one of the interference that I see from the executive is the disobedience to court orders. A judge sits down, hears a case, determines it on the facts before the court and the law. But the executive that is mandated with the execution of the orders of the court will not obey the court order. They will choose which orders to obey and disobey the ones they don't want to obey. And nothing happens. Because the court is not the executor of the enforcement of judgments. They cannot go after the executive and say, you must do this. But I'll tell you one interesting thing. I have had a case. The case has concluded, so I can tell you, because you can find it in the law reports. I had 2 election matters.
Sorry, my lord. Sorry,
Yes.
my lord. I'm so sorry, my lord. My lord, we have been informed to work within our time. I want to
Didn't give me a
appreciate you.
time.
So I'm so sorry, my lord. We're going to take just 3 minutes so that we can round up because we're giving. Sorry
Then
for
I
that.
think
I
my
ought
3
to have
minutes-
done that.
I
I'm so
think
sorry,
my
my
3
lord.
minutes is up. If you have
My
questions
lord, we
for me,
complete 3 minutes now.
Okay,
Go with
start
the
with
yes,
minutes.
with the 3 minutes. We are grateful. After that,
Okay.
Okay. I was just going
let
to
us
give you an
see.
example of where the courts can actually, if you like, in quotes, cane the executive for disobeying court order. It was 2 governorship cases that got to the Supreme Court. When the Supreme Court gave its judgment in one, and the executive decided to play hanky-panky, they allowed the case to go on, but directed all their party supporters to vote for the other party. So the person who won the case lost the seat because of the Orobo of the executive. This is not to say that the Orobo people have Wayo. I could have easily said Kano Wayo, but it's okay. I'm from Katsina State, so Katsina Wayo. Then when the second case came, because the Supreme Court now got wind of what happened in the previous case, they now slapped the executive with an order that has never happened, and they made it peculiar and particular to that case at hand. They instated the governor that did not run for election. If you are conversant with your laws, you will know what case I'm talking about. A governor that did not contest election got elected by the Supreme Court. That is the way the legislature can deal with the executive. Financial independence is a very big problem, where a chief judge has to go to the executive cap in hand to beg for funds, to do what they need to do to run their courts. It's very, disheartening. It may be slightly better with the federal courts, but at the state level, where the governor is the chief executive who dispenses the finances, even though the law, there has been judgments of the court that says the courts are independent and that their money should come from first count charge. A lot of states don't obey. This is part of the disobedience.
Thank you, my lord.
Okay.
Thank you, my lord.
I can
We are
answer
most
the rest of
grateful.
questions.
We are most grateful. We'll take all the questions, and at the end of the day, the audience we ask their questions from there. To Learned Brother Sikh Akinshe George, with due respect, the question is, my lord has taken that of financial autonomy and has also made reference to a particular case. Now, constitutional safeguard. Do the provisions of the 1999 Constitution as amended sufficiently guarantee judicial independence in Nigeria, or are further constitutional amendments necessary, sir? And go on, sir.
My Lord, the Chairman of Session, the presiding Justice of the Court of Appeal, my Lords, learned senior advocates here present, distinguished ladies and gentlemen. I will say that our problem is not constitutional amendment. Just as the keynote speaker did observe, judges are not mere referees of the law. They are custodians of justice. No matter how beautiful the Constitution may be, no matter how well drafted legislation may be, you need humans, you need judges to give life, to breathe life into the Constitution. So it's not about how beautiful the Constitution is. It is about those 3 points that my Lord Honorable Justice Danjuma Mohammed emphasized in his lecture: discipline, integrity, and commitment. Why is it that when judgments favor us, we praise the judges to high heavens? But when judgments don't favor the litigants, what do they do? They pull them down, they criticize them, they abuse them. That is hypocrisy, that is lack of sincerity. And His Lordship has said that what we need to make the Constitution work is discipline, integrity, and commitment. It's not about the letters of the law. It's about the conscience of the persons who have been called, not just to argue the law, but also to apply the law.
Thank you very much.
That is my humble submission.
Thank you very much.
Thank you, my Lord. But before I leave, my Lord, I wish to pray your Lordship for permission, sir. We came here at 11 on the dot, thinking, sir, that the event will start at 11:30.
We'll soon be
Meanwhile,
done.
we had an appointment And I'm speaking, my Lord, on behalf of myself and my brother, Sir Ken, the SCN. We had a long-standing meeting scheduled with the Honorable Attorney General of the Federation, so we'll be craving your Lordship's permission to take our leave in a few minutes from now. I pray your Lordship, sir. Yes, sir. The meeting is at 3 p.m., sir. 3 p.m., my Lord. Oh, thank you, my Lord.
Ask God, please.
Most obliged. I'm grateful, my
Ask
Lord.
God, please. And I was thinking the permission will be taken from the chairman also. All right, Frank Tete.
All right.
Quick to you. Before your intervention, I'm going to pose a question to you. How can Nigeria balance transparent judicial appointments and effective discipline of erring judges without exposing the judiciary to political capture?
Oh, thank you very much. Prof has set the example of standing up. We were given comfortable seats. I want to recognize the established protocols with particular respect and recognition for His Lordship, the Chief Judge, and Her Lordship, Justice Otaluka, a very no-nonsense judge. I've appeared before her several times, and you can feel the authority and trepidation in the court.
Your
And
time
that
is
is
running,
how
Frank.
it should be.
Your time is running.
I know. I'll say a few things. The respected Lordship, the President of the Court of Appeal, had made several copious references to the Constitution, particularly Section 81, which indicates that monies meant for the judiciary should be paid directly to the National Judicial Council. If we are talking about straining the independence of the judiciary, one of the most important ways we have seen in recent times is when, just like Her Lordship has referred to, financial intrusion. How can the Minister of the FCT, Nyesom Wike, decide to build houses for judges? If our judges needed houses, and I believe they do need houses, put the money, put that project in the budget of the NJC and pay the money to the NJC. You don't, as a minister, a political appointee of the president, decide to collect money meant for the judiciary and you go and build houses for judges and you will not think of sharing those houses to the judges. That is straining the independence of the judiciary. And therefore, I will appeal to His Lordship. When those houses are completed and Minister Nyesom Wike wants to present them to you, I'm not saying you should reject them. I know, but your Lordship must insist.
Time up.
I know. Your Lordship must insist that the houses be given to the National Judicial Council before you collect them and distribute them to His Lordship. There are several ways. I know that you are saying that there's time up.
The question also. The question.
When you say that the independence of the judiciary is restrained, I do not agree. I make comments. I am one of the only few persons on the media that will always defend the judiciary. It is a matter of perception. When the public perception is wrong, when politicians have sold a wrong perception to the public believes that the judiciary is not independent. I want to see members of the judiciary, Her Lordship, your Lordship, exercise your powers, and let's see. I see when
Mr. Frank, your time is up. Your time is up. You have not answered my question. You refuse to answer my question. And you delve into, well, it's okay, that's fine. I give that to you. My Lord, with due respect, my Lord is going to answer this question for us. Two questions. Delay and public confidence. To what extent do delay, adjournment, procedural inefficiency weaken the moral authority of the courts? And what reforms can realistically address this? My Lord, 3 minutes. I'm grateful.
Well, one of the things that you can do to curtail delays is to innovate other systems of hearing these matters. We've been toying with the idea of virtual proceedings, remote hearings, but somehow we have not been able to pick up and run along with it. So many factors are responsible. During the COVID lockdown, in the Federal High Court, we were doing virtual proceedings. We were hearing our cases by remote activities. But when you have a virtual proceeding and the internet is not working, what do? You have a virtual proceeding. There is no light in the complex. So that is one of the things. It's not that the courts are not willing and ready to innovate. They are. But the facilities to allow them to successfully implement these reforms is just not there. Secondly, yesterday I had a course list of 13 cases. Only one went on. In fact, I have judges on attachment. They were surprised. They were shocked. They said, my Lord, so this is actually what happens in court. I say, I'm glad you saw it firsthand. The lawyers will not be ready. The litigants will not come to court. Sometimes if it is exhibits that are not available. So there are so many reasons why a case will not go on. And then, very importantly, you don't have enough judges. You do not have enough judges. The equivalent of a federal high court in the country of Turkey, Istanbul, they have a population of about 55 million, roughly. We have a population of about 200 and something million. They have 250 judges in the equivalent of their federal high court. We still have less than 100. Me alone, Court 3, Federal High Court, I have over 500 cases. If I take 20 cases in a day and roll them over, you can determine how many days it will take me for each case to go around. So there are many factors. We'll get there.
Thank you, my Lord. Let us seek Akishe George, who is an academician. The question goes this way. Future of constitutional democracy. In an era of rising political tension and digital misinformation, what role should the judiciary play in preserving democratic stability while maintaining impartiality? 2 minutes. Since you want to go, sir. You'll be going to 30, so 2 minutes.
I think the judiciary should remain focused on their constitutional responsibility. You will never have a time when the judiciary will not be criticized. Judiciary will always face criticism in all climes, especially when they are involved in political matters. And politicians, just as rightly observed, would always view cases from political lenses. And unfortunately, our public is predominantly uninformed. So the loudest person usually commands the greatest following. The loudest person. And the loudest people in our country are not always right.
Thank you.
So that's the challenge we have. So the judiciary should remain focused, regardless of all kinds of opinions from the public. Truth and justice will vindicate their work. Thank you.
Thank you. Frank Tete, I want to hear you, boss, once more. Your question, the question is this: enforcement of judgment. What practical mechanism can ensure compliance with court's orders, judgment by public authorities, especially where government institutions choose to disobey?
That's a very good question.
So give me a very good answer.
Now, I was at the Legal Practitioners Privileges Committee to prosecute a senior advocate of Nigeria. Also to be prosecuted was a sitting Attorney General of the Federation, Abubakar Malami. The offense was that he refused to obey a court order. We want to see a situation where judges assert a lot more of their authority. Cite anybody for contempt, and any judge anywhere, any part of the federation will be able to carry on such proceedings against that contempt law. We are looking forward to a situation where we need to review the power of the sheriff. Must the sheriff rely always on the police to enforce judgment? Let's look at it again. I have seen situations where a high court, will order the arrest of the EFCC chairman. And I know, because of my presence in the media, how the EFCC chairman will be running from pillar to post because the judge has cited him for contempt. We want to see a situation where the sheriff is able to arrest the chief of army staff. And if they do anything to him, they will now know. We will teach them how to carry out this order. Wait. You are saying...
Your time is up.
How do we enforce... Wait. Look, wait. How can a Nigerian court issue an order and the Attorney General of the Federation will not obey it, and he will have one state council will still come and file a case in court? How? Why would the registrar accept it? Honorable Lordship,
thank you. Thank you. Mr.
I'm telling you, look, by the time when the sheriff goes to arrest the chief of army staff and they do anything to him, all the soldiers will not be paid. Let us teach them disorder.
Questions will be
If
asked.
they think that that is what disorder means,
Excuse me.
we must review
There are
the
questions
powers
to
of
be
the judge.
asked. Questions will be
Yes.
asked. Questions will be posed to you. There are law students here to learn. Questions will be posed to you. Just calm down. Wanyo. I want to believe we are having an interesting session. It started quite slow, but we thank God. Now I will just leave it open. 5 questions, then I will draw this session close. Please. 5 questions. 3 questions will be taken from the law students, and 2 questions from legal practitioners. That is it. 3 questions from the law student. 2 female, 1 male. 2 females, 1 male. Then 2 from the bar. 1 male, 1 female. I am the chairman.
My Lord, the Honorable Chief Judge of FCT.
Are you a law student?
My name is I Chief Dauda Ajadosu.
A law student?
I am a legal practitioner.
No,
secretary
please,
of the-
law students.
You said 2.
I want to start
legal-
with the law student, please. I want to
Thank
start
you,
with the
sir.
law student.
Thank you, sir.
Please. I want to start with the law students. Great law sites. Great law sites. Great law sites. Of the greatest law sites. I know you guys won't fall my hand. Please. Let's go.
Okay.
Good afternoon, everyone. Standing on the already established protocol, my question goes thus. My name is Mustafa Oyeleke, 100 level. It has been well highlighted in this panel session that public perception is important and that most public voices, or perhaps the loudest voices, are mostly wrong. So how can this be changed to ensure that the public are seeing the right side of the judicial matters? Thank you.
Thank you very much. My lord, sir. Answer.
Yes, thank you for that excellent question. I think we should clap for that student. It shows that this event is achieving its objective, because that's a question emanating from a knowledgeable perspective. There's nothing we can do about the public. We just have to keep on educating the public. The debate is an everlasting debate. And that's why the freedom of expression is important. People should be allowed to talk. Even those who are ignorant, let them talk. But it should not stop those who are applying the law from continuing to apply the law, because public opinion is an unruly horse. We cannot base the interpretation of the Constitution or of the law on public opinion. So we need to continue to educate the public, and lawyers should play their role by not joining with the uninformed to lambast, to condemn, or to destroy the system. We should participate in public enlightenment. We should participate in the reorientation of the public. Thank you.
Thank you. In 2016, we wrote a letter to the then Chief Justice of Nigeria, Justice Mahmoud Mohammed, asking the NJC to allow live broadcast of court proceedings. I cannot commend His Lordship, the Chief Judge, enough with the latest rules of court, 2025 rules, where virtual hearings have now been incorporated. It's a step forward. When Section 36, subsection 2 and 3 of the Constitution says that all proceedings must be held in public, this bad perception the public has is because they don't know what happens in the court. We believe that the judges are right, and we have confidence in the judges, but because people lie about judges, because the 5 perception indices by the MBS and United Nations Office on Drugs indicating that there's corruption in the judiciary is a narrative of either politicians or journalists. However, if citizens are able to participate in what happens in the court through live court proceedings, they will be able to form, through the broadcast of live court proceedings, they will be able to form proper opinion. So as a step forward, when the virtual hearings have now been approved by His Lordship, we are, and I must say that His Lordship at that time, as the then was Chief Justice of Nigeria, approved our request. So what we are saying, sir.
The next question, please. A female. Yeah. Just a minute. Question, very brief. Make it very brief.
Good afternoon, everyone. Already standing on established protocols, I was going to ask, when he mentioned...
What's your name?
Sorry.
Introduce yourself.
Hello, everyone. My name is Madaya Johnson. I am a 100-level student of Faculty of Law. So I was going to ask, when he mentioned that the federal governor of Abuja is building houses for judges.
Go ahead.
How do we then, in the case of where executives do things against the law, how do we then cane them? Because the reality of Nigeria and what is playing around now is that it's like judges don't have the power to sanction the executive members of...
Thank you. Frank Teti. Melissa.
Well, thank you very much. That's actually an excellent question. You see, the point is this. Even though it is a better scenario where the executive gives its money completely to the judiciary to do what the judiciary knows it needs most for the judiciary. It's not for the executive to decide what is good for the judiciary. But because the fact that the minister of the FCT is using federal government money to build houses for judges, does not mean, if you ask me, it does not mean anything. If you bring a case before my court today involving Wike and he is wrong, I will say he is wrong. So it doesn't matter. It's not his personal money that he's using to build houses for judges. It is federal government budget. The only thing is that instead of him to give the money to the NJC, which is responsible for the administration of the judiciary, he decided to do buga with it and appear to be the hardworking minister. But the important thing is for the judges to get their houses. The houses are not going to fall from heaven. Somebody is going to build them. So don't let us miss the point. Don't let us personalize the point and make it look as if it is one political score. It is not. They just misplaced where the money was, as far as I'm concerned. So please don't let us make too much of a big deal about this. There is nothing special about it.
Thank you, my lord. I think as the last question from the law students, I'll take all the questions and answers to come. The last question, one more. A female also.
Good afternoon, everyone. My name is Precious Omelu. I'm a 100-level law student. I have two questions, actually, but I think I'll go with one. Section 292 of the 1999 Constitution provides for the removal of judicial officers. My question is, how can we ensure this process is not used as a tool for intimidation or control? And then,
thank you.
Can I ask my second question?
Go ahead.
All right, thank you. And then the second question is, Section 17, Subsection 2 emphasizes the independence, impartiality, and integrity of the court. How do we move this from a directive principle to a lived reality, especially in a country like
Nigeria? Thank you very much. Yes. And let's see.
You see, the check and balance of the three arms of government is where the NJC comes in. So for you to just get up and remove a judicial officer, it doesn't happen like that. There is a procedure and a mechanism. You can't just get up overnight, and if you look at that same section of the Constitution, you find that if you have a petition against a judge, it goes to the Federal Judicial Service Commission. They make their recommendation to the National Judicial Council. The National Judicial Council may, if they think there is a prima facie case, set up a panel for you to come and defend your action or whatever allegation is against you. And then that panel will now make a recommendation to the whole body of the NJC, which is chaired by the Chief Justice of Nigeria, including several other judges on a rotational basis. If they do find that you have breached your code of judicial ethics, they can make a recommendation for your removal. But a governor cannot just get up and say, sack that judge. No. The president cannot send a message to the Chief Justice of Nigeria and say, sack that judge. No. There is check and balance when it comes to that. Does that answer your question? Okay, I think Professor Akinshe will take the second part.
Thank you, my Lord. I agree absolutely with my Lord. Nothing to add. On the second question that you asked, which also tells me that your teachers are doing a great job, is how do we translate socio-objective, socio-economic principles from chapter 2 to chapter 4? You want it to become a lived reality. That's why we have judges. Justiciability is not the same thing as implementation or enforceability. Even though chapter 2 is not justiciable, judges are required to reflect those provisions of chapter 2 in their judgment. That is how to bridge non-justiciability with enforceability. Thank you for your good question again. Thank you.
It's unfortunate, as the chairman of this panel, I want to exercise my authority to say that we've come to the end of this questions and answer session. I want to appreciate every one of you for painstakingly taking your time to be here. But I want to also use this opportunity. There's one thing we fail to understand with regards to the FCT High Court Rules 2025. My Lord has done a wonderful job there. My Lord has done a wonderful job that requires commendation. Yesterday, I prepared an application to serve someone, and I was able to put the clause there, serve through his phone number, through WhatsApp. These days, you can do virtual hearing. These days, things are seamless. I want to use this opportunity to commend my Lord that the innovation which he has brought into the FCT will continue, because we are proud to have him. And my Lord that came all the way from the Federal High Court, you might not understand. For me, I appeared in her court the very first time as a youth copper. And I've been following my Lord. I never knew today I was coming to chair my Lord. So when we started, I said, no, my Lord must speak first. I cannot be the boy student chairman to speak first. That's why I said she should speak first. My Lord is wonderful. My Lord is a figure. He's an erudite fellow. My Lord is a figure and hope to we, the female folks in Nigeria. If you go through her history, someone that has gone through the trajectory from her beginning, humble beginning in Queens, Lagos, where she became a state council, where she became the CJ of Bauchi State. Subsequently, she's also making us proud day in, day out. Our prayer is that the Almighty God will continue to keep them and bless them for all. My Lord Justice Danjuma that came all the way from the Court of Appeal, I pray that the Almighty God will keep him. The Almighty God will bless him. He's also a figure that every one of us are looking up to, an erudite fellow, par excellence, wonderful man. And we pray that every one of us, as we go back to our various destinations, the Almighty God will go back with us in Jesus' name. I hope I chaired the panel very well. Thank you. No, it has come to an end. Thank you.
Another round of applause for the panelists. I'm sure you will agree with me that was a very brilliant, exciting, and interesting session. And I particularly enjoyed the energy, particularly from Mr. Tete. Thank you all. Please still be seated. We're going to be presenting plaques of appreciation to the panelists. And to help us in doing that is Honorable Justice E.D. Zubilion, is representing the President of the National Industrial Court. Please step out, sir, to help us present plaques of appreciation to our panelists. And we're going to begin with the chairman and moderator of the session, Dr. Monday Oyekachi-Ubani, SAN, represented by Mr. Audoni. Please, okay, a round of applause. Thank you for your job well done.
On behalf of the Nigerian Bar Association, Gwagwalada branch, we present this plaque in appreciation of what you've done. Very excellent presentation. Oh, you. Okay, so we are presenting this for you for the excellent presentation. Thank you very much.
Please, let's appreciate the chairman once again, Dr. Mondewe Kachubani, SAN, represented by Mr. Audoni. Thank you for a job well done. And the next recipient of this plaque of appreciation is no other than my Lord, Honorable Justice Binta Iyako. Thank you, ma'am, for that brilliant outing there.
On behalf of Nigerian Bar Association, Gwagwalada branch, this plaque is presented to you in appreciation of participating as a panelist in the panel session of this year's annual event. Thank you very much.
A round of applause once again for Honorable Justice Binta Iyako. The next person is Professor Yemi Akinseye George, SAN. A round of applause for him.
Yes, Learned Prof, on behalf of the Nigerian Bar Association, Gwagwalada branch, we present this plaque for you in appreciation of participating as a panelist in this year's event. Thank you very much. You're welcome.
Thank you, Prof. Thank you for a job well done, sir. We appreciate you. And last but not the least is the energetic Mr. Frank Tete Esquire.
I can't say you wasted so much energy because we actually like the way you defend what you are doing. So on behalf of the NBA Gwagwalada branch, we present this plaque in appreciation of your participation as a panelist in this event. Thank you very much. You're welcome.
Thank you, the representative of the President's National Industrial Court. At this juncture, I would like to recognize the presence of the Deputy Dean, Faculty of Law, Professor J.J. Ndana. A round of applause for him. Go ahead and shout. Yes. Okay, we move on now to another very important item on the order of events. And okay, before we do the launch, I would like to invite the representative of the President of the Court of Appeal for a plaque of appreciation also. That's Honorable the representative of Honorable Justice Dongba Mensam, CFR, should come forward. Justice M.A. Danjuma, please come forward, my Lord, to receive a plaque of appreciation. A round of applause for him as he steps forward. I would like to invite the chairman of the ICPC to do the presentation, please, sir.
Okay. Let me see. This is a plaque given to my Lord, Honorable Justice Danjuma, the PJ of Court of Appeal, Abuja Division, by the Nigerian Bar Association, Gwagwalada branch, being one of these special guests of honor in this occasion, which was held on the 21st of April 2026, with the theme Judicial Independence Under Strain, reasserting the authority of courts in Nigeria, Nigeria's constitutional democracy. My Lord, congrats.
A round of applause, please.
Thank you. Another round of applause for the President of the Court of Appeal for that brilliant presentation. We move on to another big item on the order of events, and that's the launch of the journal. And of course, to help us do that will be Alhaji Abdul Wahab Mohammed, former chairman, MB Gwagwalada. Please let's appreciate him as he comes forward. Alhaji Abdul Wahab Mohammed.
My Lord, the Honorable Chief Judge of the Federal Capital Territory, the President of the Court of Appeal, all protocols duly observed. Journal launch. The branch of the Nigerian Bar Association, Gwalada branch, has decided this year to honor our Chief Judge with the journal. This segment marks a significant highlight in the event, the introduction of the MBA Gwagwalada Branch Law Journal Special Edition in honor of the Chief Judge, High Court of the Federal Capital Territory. The journal represents a deliberate intellectual contribution by the branch to the legal scholarship and institutional development. It brings together scholarly articles, critical analysis, and thought-provoking contributions from legal practitioners, academics on contemporary issues, shaping the administration of justice. The MBA Gwagwalada Branch Journal was conceived as a platform to advance rigorous legal scholarship, promote thoughtful engagement with contemporary legal issues, and contribute meaningfully to the development of jurisprudence in Nigeria. Our vision is to build a credible and enduring publication that serves as a bridge between legal theory and practice, one that speaks not only to members of the bar, but also to the bench, academia, policymakers, and wider society. We are committed to sustaining a publication that reflects intellectual depth, professional excellence, and relevance to the evolving needs of the justice system. The contributions in this volume interrogate the multifaceted challenges confronting our laws in Nigeria, which includes institutional pressure, public perception, enforcement of judicial decisions, amongst others. The articles explore both doctrinal and practical perspectives, offering critical insights and forward-looking recommendations aimed at strengthening our laws in Nigeria. In producing this volume, the editorial board adopted a rigorous and structured process designed to ensure quality, credibility, and scholarly integrity. Contributions were received from distinguished jurists, senior legal practitioners, and academics. Each submission underwent careful editorial scrutiny, including review for clarity, originality, analytical depth, and relevance to the theme. This process involved detailed editorial review and refinement, consistency in style, citation and formatting, quality control to ensure coherence and scholarly merit. The Honorable Chief Judge of the Federal Capital Territory, sir, I have the honor and privilege, sir, to invite you, sir, to come forward, sir, so that Mr. Hassan Lukman will do justice to... What are you going to do? No, we don't want to. We want to know who are we. The Honorable CJ, sir. Yes, sir. The citation of the CJ, sir.
With the kind permission of my Lord, the Honorable, the Chief Judge of the High Court of the Federal Capital Territory, Abuja, may I proceed to read the brief profile of my noble Lord. Honorable Justice Hussaini Baba Yusuf is the Chief Judge of the High Court of the Federal Capital Territory, Abuja. He was sworn in as a substantive Chief Judge on October 26, 2021, by the then Chief Justice of Nigeria, Honorable Justice Ibrahim Tanko Muhammad, following his earlier appointment in acting capacity on August 1, 2021, after the retirement of Justice Salisu Garba. My Lord's appointment marked culmination of decades of distinguished service in the Nigerian judiciary. You may be interested to know the early life of my noble Lord. Honorable Justice Hussaini Baba Yusuf was born on 1st of June 1962 in Ankpa, Kogi State, Nigeria. He hails from a humble and disciplined background that shaped his strong moral and professional values. His early educational pursuits reflect a steady commitment to excellence. He began his early education at Sacred Hearts Primary School, Ankpa, where he studied from 1966 to 1971. He proceeded to St. Charles College, Ankpa, for his secondary education between 1972 and 1976. My Lord, driven by a passion for higher learning, attended the School of Basic Studies, Ugbokolo, Benue State, from 1977 to 1980. Thereafter, my Lord gained admission into the University of Lagos, where he obtained his Bachelor's of Laws degree between 1980 and 1983. He subsequently attended the Nigerian Law School and was called to the Nigerian Bar in 1984, qualifying as a barrister and solicitor of the Supreme Court of Nigeria. My Lord's judicial and professional milestones. Honorable Justice Baba Yusuf began his illustrious judicial career in 1985 when he joined the Kogi State Judiciary as a magistrate grade 2. His diligence, integrity, and exceptional administrative acumen earned him rapid advancement. In 1993, he was appointed the Chief Registrar of the Kogi State High Court. In the same year, my Lord transferred his service to the FCT Judiciary, where he served as Deputy Chief Registrar. My Lord's continued dedication and professionalism culminated in his appointment as a judge of the High Court of the Federal Capital Territory in 1998. Over the years, my Lord has distinguished himself on the bench through sound judicial reasoning, courage, and adherence to the rule of law. Notably, he presided over several high-profile cases, including the trial of the former National Security Advisor, Sambo Dasuki, involving allegations of diversion of arms procurement funds. On August 1, 2021, my Lord was appointed in acting capacity as the Chief Judge of the FCT High Court by virtue of his seniority and proven competence. He was confirmed and sworn in as the substantive Chief Judge of the FCT High Court on October 26, 2021. My Lord has brought a lot of reforms and contributions to the FCT judiciary. As a Chief Judge, Honorable Justice Baba Yusuf has demonstrated visionary leadership and commitment to modernizing the judiciary. Under his stewardship, the FCT High Court has witnessed significant reforms, including introduction of digital filing system, the adoption of virtual court proceedings, and the establishment of specialized courts to handle sexual and gender-based violence cases. These innovations have enhanced access to justice, improved efficiency, and strengthened public confidence in the judicial system. For his noble and worthy service to the nation, my Lord has received a lot of recognitions, and part of it is the recognition of his outstanding contribution to the administration of justice. in Nigeria. This has received several accolades, including awards celebrating his excellence and integrity on the bench. At the time of his appointment as Chief Judge, he was the most senior judge of the FCT High Court, underscoring his experience and leadership within the judiciary. Honorable Justice Hussaini Baba Yusuf stands as a symbol of judicial excellence, integrity, and dedicated public service. His career reflects an unwavering commitment to the rule of law and advancement of justice in Nigeria. As a Chief Judge of the FCT High Court, he continues to play a pivotal role in shaping the future of the judiciary and upholding the principle of fairness, equity, and accountability. My Lord is a family man married with children. My lords, learned senior advocates, senior academics, ladies and gentlemen, I present to you the Chief Judge of the High Court of Federal Capital Territory, Honorable Justice Hussaini Baba Yusuf. Please, he deserves a standing ovation.
Thank you. We are grateful, sir. Next is the unveiling of the journal and the launching of the journal. Mr. Chairman, sir, we have the journals to be unveiled here. I respectfully, sir, invite Mr. Chairman to come over to this side, sir. The President of the Court of Appeal, sir, the Chairman of the ICPC, Honorable Justice Yako, the Grand Cadre, ably represented, National Industrial Court President, the Learned Sikh AT Kehinde SAN, Professor Akinseye George, SAN, Professor Josephine Agbonika, the chairman of the organizing committee, my Lord Justice Shafa and my Lord Justice Binta, my Lord Justice Aino,
Very distinguished ladies and gentlemen, I'd like to acknowledge the fact that we have spent the day, we've gone very far in the day, and there is need to go about this expeditiously. To do the unveiling of this journal, I'd like to invite Professor Abugu, the Dean of Law, University of Abuja, to join us at this side. I know that as lawyers, we are known for being organized. So, in order to go, in order to go through this segment in an orderly manner, I'd like to announce to the crowd that the chief launcher to the glory of God will be my brother, A.T. Kehinde SAN. I know that the branch has expended money and time to put this journal together. And as ministers in the temple of justice and as guardian of the conscience of this profession, we have a responsibility to support them. So Etikende will, as chief launcher, preside over the launching of this book. My brother, the chairman of the ICPC, will be here to support him. The rest of us on the high table, where is my brother, Professor Akinshe George? Is there. I mean, when we have a forum like this and he's not present, then something is missing. I'd like to say that I am very proud of your effort. You have done a lot to ensure that the stream of justice in this country runs smoothly. May God bless your effort. In order not to waste time, there's a space for Chief Judge Chairman's remarks. I am now doing that remarks. I'd like to thank the branch for sustaining this legacy over the years. There is no doubting the fact that it requires a lot of time, a lot of resources to be able to organize this type of thing. And I congratulate you for ensuring that this continues to happen. For me, I will be available to encourage you and to support you to ensure that the branch continues to work stronger. Distinguished personalities that have done your event today bears testimony to the importance that is attached to this, this event. My Lord Justice Nyako, Abinta Nyako was here as early as 10 o'clock, and it didn't start until 12 o'clock. I know as a matter of fact that she's a very, very busy judge. My Lord, thank you for your time. My brother and call-mate, the presiding justice of the Abuja division of the Court of Appeal, my Lord Justice Danjuma, you are wonderful. May God bless you. This statement is a way of welcoming you to Abuja division, and may you continue to have an illustrious career. For the rest of us who are here, I'm happy to have you support us at this event. May the good Lord bless you. Independence of the judiciary is at the core of rule of law. Without it, there will be disorderliness in the society, and then there will be chaos. A lot has been said about it, and I do not intend to add more. We have had you in your various presentations, and we are happy. We're going to have takeaway from this event. So having said that, I'd like to now invite the rest of us here to join me in unveiling this, and then to also hand over the microphone to Etikende SEN, who will lead us in the launching of the journal. Thank you for listening.
Thank you, sir. Applause.
It's proper that all of us would display the journal to the public as the media is capturing us. I like us to all hold it and then display it to the public. So after the journal has been robustly launched by those of us at this end, I will be imploring all of us, the rest of us, members of the hall, to also support by launching the journal in your own way. That is the way we can encourage what the bar is doing
and to ensure that this tradition is sustained. Thank you so much. And having said that, it is now my honor and singular privilege to hand over the microphone to the chief launcher, my brother, Chief A.T. Kinde, SAN. Thank you.
My Lord, the Honorable Chief Judge of the FCT, a man of impeccable character, a man that is likened to the description given by the Holy Bible, a man without guile, no deception. My Lord says it the way it is, and you can rely on my Lord 100%. And that is why each time there is anything involving my Lord, my friend and my brother of 46 years relationship, Professor Akinseye George, 46 years. We make it a point of duty to attend everything concerning my Lord, except we are not aware of it. And so, my Lord, we want to congratulate you, sir. We are so happy, we are so proud, we are so delighted to associate with you, my Lord. I see it as a very rare privilege to be called upon to be the chief launcher of this journal. I didn't have any notice that I'll be so directed by my Lord. But I'm a man under authority. It's as if my Lord Justice Nyako will also give me a mandatory order. I have no choice but to carry it out to the letter. So I'm humbled, I'm honored, my Lord. I believe in the principle that what your right hand is doing must not be known to the left. But I will ask the organizers. I can see the array of law students here. This year makes it 40 years when I got called to the bar. So if you put 40 years with the number of, I think we spent 4 or 5 years in the university. And so you can imagine. So I'm excited because we are the future of this profession. You are coming into a noble profession, and the secret is that you must have an appetite for reading. Read and read and read. And so I'm going to respectfully ask the organizers to please make a copy each available to all the law students who are in this hall. Every student in attendance must have a copy. And the bill will be sent to me, the cover price for each of the copies that will be given to them. Secondly, in order to encourage the Gwagwalada branch, I will also support very handsomely. Very handsomely. Because what you are doing, most other branches will be busy organizing lunches and dinners and what have you. But you are putting something on the table that will be everlasting. So we're encouraged. And may you continue to soar, just as your name is, the eagle. May you continue to soar and soar and soar in excellence. Thank you so very much. May I know I can see some money bags here. So I'm going to call on the chairman of the ICPC, who is my deputy chief launcher, and the brother Silk. Is also an SCN. He's a member of the inner bar. And let me also tell you one secret about him. Whatever is going to be the launching that he will be putting forward this afternoon, don't think that he's making it from the government. It was a money bag before he got the appointment as ICPC chairman. So, my brother, thank you.
My Lord, the Chief Judge of the FCT, all other distinguished personalities here present, the other sec has said that I was money bag. I wasn't. So I want to thank the Gwagwalada branch of the MBA for this intellectual work. I think Gwagwalada branch, I can say, is dear to me. Apart from Kano Bar, I think Gwagwalada branch is the branch that I have been attending because of what I have seen you have been doing. And you know, we are working in an agency which believes in transparency and accountability. So ICPC is going to get 5 copies in the sum of ₦500,000 naira.
Thank you. Thank you. Professor Yemi Akinche, George.
Thank you. Thank you, my Lord. Thank you, my Lord. It's indeed an honor and a privilege to be associated with this journal, which is dedicated in honor of my Lord, Honorable the Chief Judge of the Federal Capital Territory. I lead a center for social legal studies. We will purchase 100 copies in support of the branch. Thank you.
The representative of the managing director of Nigerian Deposit Insurance Corporation. Is he still around? Yes, he has left. Social Insurance Trust Fund. He has also gone. Okay. Now I call on the Honorable the Grand Cadi of the Federal Capital Territory, ably represented, to make his launch.
Thank you very much for giving me the opportunity to say a word or two about this. I have the instruction of the Honorable, the Grand Cadi of Sharia Court of Appeal, FCT, to launch this journal, 5 copies, at the rate of 500,000 naira.
I deliberately avoided my Lord Justice Binta Nyako, but because usually you don't bring out the big masquerade too early. My Lord, who I know operates in multiple capacities, would launch this journal handsomely. So, my Lord, we need your support.
Well, my Lord, I'm very proud of the Gwagwalada branch of the MBA. When I became international president of the International Association of Women Judges, they actually paid me a courtesy call. They registered with me, and I was very proud of them. They were the only bar branch that recognized that achievement for Nigeria. So particularly because it was led by my friend, Josephine S.A.N., and my brother, the Chief Judge of the FCT High Court. If he calls me on any day, I will try and make sure that I'm available. So I adjourned all my cases for today just to be here because he's my brother. Well, you know we are on salary. In fact, they've not paid April yet too. But I'm proud to take just 1 copy for 100,000 naira.
Thank you, my Lord. And I have been told that the High Court of the Federal Capital Territory desires to launch this book to support the branch. In that stead, the Chief Registrar of the High Court has delegated the Director of Litigation to announce the support. So I'd like to invite the Director of Litigation, Ms. Shade Oyekon, to announce the High Court launch on behalf of the Chief Registrar.
Good afternoon, my Lord, the Honorable CJ. Good afternoon, my lords, distinguished members of the High Table. On behalf of the High Court of the FCT, on behalf of the Chief Registrar, Hajia Muhammad Hadiza Dodo, she has asked me to launch 50 copies for 2 million naira. Thank you.
Thank you. Thank you. Thank you. Thank you. Thank you. Other than that, we are a society trying to maintain a tradition, a society that is trying to improve on its activities. I wouldn't have invited the professor of law, dean of law, for a lunch. The reason is simply that he has been generous to donate this hall to us, acting in concert with the vice chancellor of the university. That would have stood as a sufficient launch of this journal. But I think that knowing whom he is, as someone who has very high passion for whatever has happened in the legal industry, I'd like to invite him to make a statement and launch this journal.
Thank you. My Lord, the Chief Judge of FCT, all the dignitaries which the CJ, by his status, has attracted to our faculty, I welcome you all. Please, can you clap for them? I want to sincerely appreciate our branch, Gogolada branch of NBA, for listening to the voice of reason to bring this lecture to this faculty. I know we started hosting this lecture last year, and by the order of my senior brother, the CJ of FCT, it shall continue to be so until further notice. I'm happy that my Lord, the CJ has realized or recognized the fact that we have started donation even before the lecture. We donated last year, we didn't ask you for 1 kobo. We are donating, we are not asking, but we continue to donate. We will not be tired, sir. When it came to this item, I put through a call to my boss, the Vice Chancellor of this university, who himself is a cerebral academic. And I told him that the CJ, your brother and your friend, this journal is being launched in his name, and he would want you to be here personally. And he said he has already explained to the CJ why he's not here. But I should inform the chief judge that certainly, and I am putting my own honor on the line, that certainly the Vice Chancellor will do something to honor the Chief Judge of FCT High Court. And to appreciate Leonard Silk, Leonard Good of Nigeria, for donating a copy of this journal each to all my students. I want to say that in the just released law school result, my students, 3 of them made first class. And because of this, your donation, I'm assuring you that the next batch of law school results, we are going to harvest so many of them more. And On behalf of the Faculty of Law, a token of appreciation and a token of welcome, because the Chief Judge came to this office for the first time today. And in the name of the Faculty of Law, we are launching just a copy, because all my students here will get one copy, just a copy for the Dean's office. Okay, 3 other copies, 4 other copies for each head of departments. Yes, just take 100,000 from the Faculty of Law. I'm most obliged, sir.
Generous. Thank you for being generous. And before we get to the public, I'd like to thank you for your patience. I'm also here with some of my judges who have whispered to me that they are anxious to make handsome contributions. So I'd like to invite my Lord, Honorable Justice Marian Aneni, who will announce her donation. And I know that she will do it very well. Is one of my judges who has vowed not to disappoint me on an occasion like this.
Thank you, my Lord, the Honorable, the Chief Judge of the FCT, and all other dignitaries here present. My Lord has said it, that I vowed not to disappoint him. He's our leader, and we see him as our daddy. So I would not disappoint him. In everything, we look up to him. He's the one that speaks for us. So I would want him to speak, announce on behalf of all of us. Yes, my Lord. And we will surely make do whatever you ask us to do.
My Lord, I understand, my Lord, to have said that we were speaking on behalf of the rest of the judges. My Lord Justice Atanuka, you still want to do something outside that? Eh? So, well, it is only proper that while we are waiting that, I invite my Lord Honorable Justice Jude Nwubuze to do an intervention. Thank you, my Lord. I know that you are bound. I want you to understand that you are bound by the State Bank, my Lord Justice Aneni, irrespective of that, and knowing that you are the only male. Okay, somebody else is there. Nevertheless, I invite you to do an intervention.
Good afternoon, my Lord. I beg to stand on all the existing protocols. Well, my Lord, this is a very heavy one. My Lord, our senior has already said we are standing under your umbrella. I cannot but concur. Thank you, sir.
Now, we have one of the panelists who has also indicated an intention to support us. Mr. Tete, where is he? When he spoke forcefully and energetically. I want to understand him to be saying that when it comes to this type of event, this segment of the event, he would also speak loudly.
Thank you, Your Lordship. Without wasting much time, this will take a copy. Okay, for all the lawyers to take a copy for the sum of 500,000 naira.
That's a good one. I'd like to thank you all. You want me? How much is it? Okay. So, my brother representing the president of the National Industrial Court is taking 2 copies, you said? Yes, he's taking a copy for 100,000. A round of applause for him. At this level, I'd like to thank the audience once again and to invite members of the public to do individual launch of this journal so that we can keep the publication ongoing. Thank you for your patience. Thank you for your support. We're proud of you all. Thank you. Iname Jemu. We can now sit down, please.
Your Lordship, sir, we are very grateful.
Please, just a moment. Please, Your Lordships, kindly remain standing so you can for a group photograph, so we don't have to bother you to come.
Group photographs.
Group photograph,
Group
sir.
photograph. Group photograph as group photograph. Group photograph. Your Lordship. Group photograph. Oh yeah. A quick one, a quick one. Thank you. We are very grateful, sir. Both of them. NC Nwachukwu. The chairman.
RCD.
We're gradually coasting home. DJ, please
Mr.
bring it
Adewaku.
down.
Please, the account of the branch. Mr. Adewaku.
DJ, thank
The vote
you.
of thank.
Before the vote of thanks, please, I'd like to appreciate everyone once again for your huge support and generous donations to the launch. And the account details of the branch is Access Bank 0029102474. I'll take that again. Access Bank 0029102474 for your donations. Thank you. And to give us the vote of thanks is your worship, or our worship, my sister and friend. All right, go ahead.
My Lord the CJ, Honorable Justice Seni Baba Yusuf, distinguished members of the High Table, good evening, or afternoon, it's afternoon. I'm here to perform it's simple, but it's quite big. You know, when you've been called upon to perform a role by your mother, your teacher, a mentor, you dare not say no, you can't decline. So I'm here to perform that role. Thank you so much, ma. My Lord the CJ, we want to say a big thank you. And permit me to speak Igala. My Lord Agba. And to go further, Agba Kochu. Did I get it right, my Lord? Thank you very much for coming. My Lord has a lot of things to do and to attend to, but he still made out time to be here. That shows he has the MBA Gwagwalada branch at heart, and we do not take it for granted. Thank you very much, my Lord. To our judges here, we know you should be in court, listening to long arguments, ruling, saying granted, or you decline, you know, adjourning for judgments and rulings. But you took out time to be here. We are sincerely grateful. We say thank you. To the senior advocates here, you should be with your wigs and gowns, sweating, shouting, citing laws and saying, this is my provision. My Lord, I rely on this, I rely on that. But today you decided to take a break to celebrate with the MBA Gwagwalada branch. We say a very big thank you. We appreciate your presence here. To our lecturers, I can see my dean, my father. You know, University of Abuja bettered me, and I'm proud to associate myself with University of Abuja. You know, to the dean, Faculty of Law, and our lecturers here present, we say a very big thank you. You should have been in your various offices or in your lecture rooms attending to the students, but you are here. We do not take it for granted, and we say thank you. To our students here, thank you for making this hall beautiful. Thank you for paying rapt attention. Thank you for asking intelligent questions. You could see that the panelists were on their toes and wondering, these questions coming from students. You did us proud. Thank you very much. To the media crew, thank you. And I will not end here, but I will have to say thank you to the organizers of this program, ably chaired by our able Professor J.A. Abonika, Senior Advocate of Nigeria. Please, a round of applause for her and her committee members. Thank you for chairing this occasion. It was indeed insightful, learning. It brought back memories and is driving us home. Thank you very much. At this point, with a round of applause, we say thank you. We say nagode. We say eshegon. But I don't know it in Igbo, so please interpret it. Thank you, and I wish you a safe drive home.
Another round of applause for your worship. Thank you. You did a good job of that. Thank you, thank you, thank you. And I think we have come to the end of today's event. Distinguished ladies and gentlemen, and as we bring to a close the 2026 Chief Judge Annual Lecture of the Nigerian Bar Association, Gwagwalada branch, the Eagle branch, We reflect deeply on the profound theme that has guided our discussions: judicial independence under strain, reasserting the authority of the courts in Nigeria's constitutional democracy. And today's deliberations have laid bare the realities confronting our judiciary, while also illuminating the path towards restoring confidence, strengthening institutional integrity, and safeguarding the rule of law. We have not only examined the strain, we have reignited the resolve to reassert the authority of our courts as a cornerstone of justice and democracy. And on behalf of the organizers, I sincerely appreciate our distinguished chairman, eminent speakers, panelists, and all participants for your invaluable contributions. As we depart, may we carry forward the insights gained here into action, ensuring that the judiciary remains strong, independent, and unwavering. Thank you all, safe travels, and God bless the Federal Republic of Nigeria. My name is Mariam Okesonjo. Thank you all, and have a nice day.
You think I could have get enough feelings?
Photographs, please.